Mr. Harty, you are the appellant in the certified question. You may proceed.
Thank you, Your Honor. May it please the court. Frank Harty on behalf of Allsteel. With me at council tables, Fran Haas. We also have with us Becky Schmidt, in-house counsel with Allsteel. May it please the court. It seems that with statutory and constitutional interpretation issues, it's easy to make things overly complicated. It seems that in this case, simplicity yields clarity. Here it's simple. Iowa Code Section 216.6a, what I'm going to call, with your indulgence, the Iowa Equal Pay Act, clearly states that with each paycheck, there's a new actionable violation of the law. Thus, unlike a hostile environment claim, it's very easy to determine when a violation occurs. This is vitally important in these claims because it establishes, it demonstrates that there's simply no way that the claims could have accrued until the law was passed in 2009. In the plaintiff's attempt to conflate damages and how they're described with the accrual of a cause of action leads to confusion. We'll first address the first certified question by Judge Rose. We asked that the court answer no to this question, and we simply point out that the statute creates an entirely new radical cause of action that's different from anything we've seen here in Iowa. It creates a strict liability claim with affirmative defenses and enhanced remedies. Again, unlike
this, though, prior to the enactment of this legislation in 2009, to prevail on a wage discrimination claim, I think everybody agrees that you had to prove intentional discrimination. There may have been some shortcuts under McDonnell Douglas, but you had to prove intentional discrimination, right?
That's right, Your Honor.
Now you don't have, you just have to prove the wage discrepancy, but it's an affirmative defense that the discrepancy was not due to discrimination, more or less. So how is that so different?
It's entirely different because there is absolutely no intent that has to be proved in order to establish a prima facie case. And there's no other anti-discrimination law in the state of Iowa that has that proof standard embedded in it. This is a strict liability statute, and virtually every single defendant, once there is shown to be a pay disparity, is going to have to plead and prove an affirmative defense. And the damages provision is also unique in that it does not vest the court or the jury with any discretion concerning damages. It says it shall be double or triple damages.
But on the damages side, it seems to me on the damages side, we've said in the past that legislation that merely enhances the damages for conduct that was already violative of the law, that can be presumptively retroactive. But legislation that, on the other hand, changes the liability standard, that's presumptively prospective. Isn't that what we've said in the past?
You have said that, Your Honor. And that's why it's important to read both the liability provision and the damage provision together. 216.6a in its title provides that it creates an additional cause of action. And 216.15.9 makes it clear that the damages, the enhanced damages, are available only for a violation of that new strict liability statute. Therefore, when read in tandem, it's clear that a new cause of action was created. This was no more of a tweak, if you will, of the Iowa Civil Rights Act than was the addition of sex discrimination in 1970, or the addition of age discrimination in that same year with a different act, or the addition of disability discrimination in 1972, or the addition of sexual orientation discrimination in 2007. These were all radical new changes to the law, just like this is.
Well, but in prior law, there was a claim for wage discrimination from the very beginning, based on sex. What you had to prove has changed. I mean, I think everybody has to concede that. Under prior law, discrimination had to be a motivating factor, if I have it right. And now under the new law, you have a different framework for showing wage discrimination. But the general topic of recovery for allegedly discriminatory wages based on sex has been around since 1965, surely. And what I think the real issue here is when does something become remedial? Where do you draw the line? This is what we're all talking about, but where do you draw the line between something that's remedial and therefore retroactive or possibly retroactive, and something that is more substantive? And you're kind of saying, well, this is a whole new offense. Frankly, I'm not quite so sure of that. You haven't quite convinced me that it's a whole new offense. I do understand that the proof has changed and the burdens have changed. And I also understand that there may be some instances of recovery under what I'll call the new statute that might not have been recoverable under the old statute. But where I'm not yet sold is the notion that means that this can be prospective only. I've asked a whole host of questions here, but I think you understand the thrust of what I'm saying, and
I do, Your Honor.
I invite your response.
If I might try to approach this on two levels. First, with regard to the remedial nature, okay? This entire statute is remedial, arguably. And this court has on a number of occasions said you can't take that to the extreme limit. And that in fact, the mere fact that this might be remedial, that the statute's remedial, it's intended to remedy the evils in society of discrimination.
I think you're right, by the way, adding a new class. I mean, it's a remedial statute generally, but you add an entirely new class of claims. That might be one thing, but that's not quite what happened here.
Well, I might, if I might, Your Honor, let me address that with first looking to the language of the statute, which in its title says it's creating an additional cause of action. It's not clarifying. It doesn't say, as in the preamble in the Turner case, that it's changing or making it more efficient. It says, the legislature at least believed, it was creating an additional cause of action. And this court has to accord a great degree of weight to that. And then second, the damage provision describes the damages as being available only for this new discriminatory, this additional cause of action created in the initial 6A. If I might, maybe perhaps I can close by providing a couple of hypotheticals that demonstrate the radical differences here. The amicus brief contains a hypothetical about a law firm hiring new lawyers. Let me take that and use that hypothetical, but change one fact. And that, let's assume that this law firm is desperate to start a tax practice in the state of Iowa. So their new hires, they've made it clear that they will pay any lateral $5,000 more than their current salary. All you have to do is demonstrate to us what you're making at your current law firm. And that results in a male and female being hired, with the male being paid $5,000 more than the female. I don't think there's any question that that does not constitute a violation of what I'll call the old Iowa Civil Rights Act. But without question, that constitutes a prima facie violation of the new strict liability law, and it's incumbent upon the law firm to establish, to plead and prove one of the new affirmative defenses. I don't know how you can look at those two very different causes of action and say that they're simply different flavors of the same ice cream, if you will. And another hypothetical, I'll close by emphasizing one thing. This really isn't about sex discrimination. It was Secretary of State Hillary Clinton, I think, who said that human rights are women's rights, and women's rights are human rights. That's especially true in this case. And if you assume that the plaintiffs in this case were alleging that they were the victims of discrimination because of their sexual orientation, because of their sexual preference. It would be extremely difficult to make a case for their ability to recover damages that go back a decade or a decade and a half, as the plaintiff is attempting to do in this case. But that's exactly what the interpretation urged by the plaintiff does, because this law, this new strict liability law, applies to every class of protected persons in the state of Iowa, not just sex discrimination. Unless the court has additional questions, we would ask the court to answer no to the first certified question, and we believe the response to the first certified question informs and dictates the court's response to the second question. Thank you.
Thank you as well, Mr. Harty. Ms. Brown-Graff?
Thank you, Your Honor. May it please the court. The Iowa Civil Rights Act has prohibited wage discrimination since it was first enacted in 1965. And despite this clear mandate of equal pay for equal work, along with the same mandate contained in 2 federal statutes, some employers have persistently continued to pay women less than men performing equal jobs. In 2009, the Iowa legislature, clearly prompted by the enactment of the federal Ledbetter Fair Pay Act, amended the Iowa Civil Rights Act to more effectively address wage discrimination that has persisted despite this clear mandate of equal pay for equal work. And the amendment accomplished 3 objectives. It codified the paycheck accrual rule by adopting identical language contained in the Ledbetter Fair Pay Act, therefore eliminating any risk that Iowa's Civil Rights Act would ever be interpreted in the manner that Title VII had been in Ledbetter. The amendment also codified previous case law allowing for recovery during the entire period of discriminatory conduct and added enhanced remedies for equal pay violations. And the amendment altered the manner in which persons who had suffered pay discrimination could prove their claims by adopting the burden of proof framework that is contained in the Federal Equal Pay Act.
Did you say,
If I may invite you to address part of Mr. Hardy's argument, as I understand it at least, he says, well, yeah, there's been some changes in the framework of how you prove a case, but more than that, he says that with the new statute, there will be occasions where liability will be found, where under the old statute there would not have been liability. And as a result of that, we should not regard this as a remedial measure.
Well, the same conduct is punishable under the old act and the new and the Amendment Act. The question, the real change is who has to prove the intent. So prior to 2009, the employee had to prove that more likely than not, sex was a motivating factor. But all of the same evidence would be introduced. And now the employer has to prove that another factor other than sex or the membership in a protected class was the motivating factor. So
doesn't that, and I understand it makes it an affirmative defense that it was not discriminatory or intended to be discriminatory, but isn't that going to shift some group of classes? I mean, I think even you would acknowledge this. Some group of classes that would be losers for the plaintiffs under the old law are going to be winners for the plaintiffs under the new law, right?
there are no claims that can be pursued now that couldn't be pursued, but the plaintiff's burden is easier under the new law, which quite frankly makes more sense because the employer has access to the basis for the pay discrimination. So it's appropriate for the employer to be responsible for proving their intent in discriminating between a male and a female employer. And the dramatic difference that Allsteel points to is in fact so sort of abstract and minuscule that the majority of federal circuits refuse to apply the difference at all. So the majority of the federal circuits, including the Eighth Circuit, treat all wage discrimination claims, whether brought under Title VII or under the EPA, using the EPA's burden shifting framework, meaning that the employer is responsible for proving their intent, despite what the defense has characterized as a dramatic difference. It hasn't been viewed significantly enough by the federal circuits to actually instruct on it.
That's not how we've applied the Iowa Civil Rights Act in the past. Haven't we, under our Iowa Civil Rights Act, prior to this amendment, said, all right, there's McDonnell Douglas, but I think it was the chief, in an opinion a few years back, said that once you get to trial, it still remains ultimately the plaintiff's burden to prove discriminatory intent.
Well, this court addressed the burden of proof on an equal pay claim in the Buchanan County case, and the court there made clear that really what you're talking about is a difference in the burden of proof, where the same evidence would be presented, but the administrator in that case had not appropriately considered the evidence that the employer put on for the basis of the pay discrimination.
But in that case, didn't we contrast the Equal Pay Act, Federal Equal Pay Act, and say that's strict liability? Make the same point kind of Mr. Harty's making now.
The court said that it was strict liability, but then in fact the court remanded it and instructed that the administrator should consider the evidence offered by the employer under a different burden of proof, meaning that the employer should not have, in that case, before the enactment, should not have the responsibility of proving the basis for the pay discrimination, that ultimately lie with the plaintiff. And so, I mean, I think the defendants are hard-pressed to point to this as a change in anything other than the burden of proof.
What about, let me talk about the ability to go back in time, because you raised that earlier in your discussion. It's your position, as I understand it, that the 2009 legislation merely codifies what you do believe to have been pre-existing Iowa rules. For example, if you had been discriminated, if you had been an employee, say, for 10 years, and you were being paid less than a man for comparable work, that you could sue for all of those 10 years. Is that
right?
That's your position.
Yes.
Now, that goes beyond even what Justice Ginsburg said in dissent in the Ledbetter case, right?
Justice Ginsburg said in the dissent that there would be certain defenses that would be available to an employer in that
I mean,
case.
there's sort of three positions here. One is when there's someone, let's say, who's been an employee for 10, 20 years. One position is that if the majority in the Ledbetter case that was overruled by Congress, the majority position was if it had its origin back 10 or 20 years ago when this employee started work, then too bad, they can't collect a differential. So that's been overruled by Congress. The second position, which I understand is yours, is under some kind of continuing violation theory, you could go all the way back 10 or 20 years and then the position that I thought was the contrary position in the federal courts that was in some of the federal courts that was overruled in the Ledbetter case was each one is a discrete violation and you can go back within the statute of limitations to get at the paychecks where there was a differential. So am I right?
Well, first, there's a distinction between Title VII and the Iowa Civil Rights Act that this court aptly noted in High V, and then there's not a limitation on damages. And the difference between the circuits prior to Ledbetter was, I mean, the majority of the circuits, as we've set forth, found that it would be timely filed if filed within receipt of a discriminatory paycheck during the 300 days. And then the circuits were divided as to whether or not the plaintiff could recover 2 years of back pay or were limited to the 300 days in the administrative filing period. And the Senate overruled or resolved that dispute as well by concluding that they could recover
Nobody under interpreting Title VII said you could go back 10 or 20 years.
No, because there was a 2-year limitation on back pay in Title VII that's not contained in the Iowa Civil Rights Act.
Right, but we still have a statute of limitations. I mean, you could have had a continuing violation theory, couldn't you, under Title VII?
Well, you could have. The court, it's unclear whether the U.S. Supreme Court in Morgan rejected the continuing violation theory, as opposed to, Justice Ginsburg has said that they, in fact, did not, that was not the intent of what they did in Morgan. But Iowa law is different from federal law in that this court has expressly adopted a continuing violation doctrine, and the Iowa Administrative Code, which, in order to eliminate a continuing violation doctrine, would have to be overturned by this court as.
But we haven't applied it yet in a back pay scenario.
No, you have not. And so I think even if Morgan is read to conclude that that the federal courts don't have a continuing violation doctrine, even if this court were to conclude that it had in fact adopted Morgan in its entirety, which I don't think is true, the court could still uphold the timeliness of the paycheck accrual rule based on the reasoning of Justice Ginsburg in the dissent. In fact, that was post-Morgan. The majority of the federal circuits applying Morgan concluded that the paycheck accrual rule was applicable to determine the timeliness of the filing. And there are two separate issues regarding the timeliness of the filing and the amount of the damages that are recoverable. And I think that the amount of the damages that are recoverable was answered by this court in the Hy-Vee decision, in which they allowed recovery of back pay for 7 years preceding the filing of the administrative complaint. And we have argued, which I have not yet addressed, that in fact Allsteel being on notice that its conduct would subject it to substantial damages if it continued to engage in wage discrimination post-2009, did violate 216.6A after 2009, and the damage provision could not be clearer in allowing recovery of damages for the entire period of discriminatory conduct. So it is our position that it is not necessary that the 2009 amendments be found retroactively applicable, but if the court determines that it is, that they should be determined retroactively applicable, because the changes constitute a change in the damages available and a change in the burden of proof. And those two changes this court has held are presumptively retroactive. And I think reading the statute of the Iowa Equal Pay Act, I think even further supports that with the legislature's stated purpose in enacting the statute to correct what it recognized as persistent wage discrimination despite express statutory prohibition. If the first certified question is answered to provide for recovery, as the statute clearly provides, during the entire period of discriminatory conduct, then I don't believe that that Judge Rose contemplated that the second question would need to be answered. But in the event that the court does feel that it's necessary to address the second question, we believe that the court, I think that it has long since been the law of this state that recovery is allowed during the entire discriminatory period. And as an attempt to sort of end run around that, what Allsteel has argued is that the plaintiff's claim was not timely because while filed within 300 days of being affected by of receiving discriminatory paychecks, it was not filed within 300 days of first receiving discriminatory paychecks. And I think for all of the reasons set forth by the majority of the circuits and by Justice Ginsburg's dissent, that is not what was intended in 216.6 to prohibit those types of wage claims, which are clearly continuing and often hidden in nature, by providing that they're...
To follow up on that area I was asking about, I mean, I understand kind of the point, the force of the argument made by Justice Ginsburg and others in criticism of the majority in Ledbetter, but is there any jurisdiction in the country other than Iowa, as you contend, where if somebody today brought a wage discrimination claim, they could reach back and say had been employed by the same company for 30 years, they could reach back and get 30 years worth of wages?
No legislature has enacted a statute that
Has
the
any
Iowa
court-
legislature has enacted.
Right,
which
I
says-
understand the breadth, and I see that reading of what what's in 216.6. So no other legislature's gone that far. Has any court gone that far? Any other state court anywhere gone that far under their legislation?
I'm not aware of whether any other state courts have gone that far. A number of the other state civil rights statutes mirror Title VII, including a 2-year limitation on back pay. The Iowa legislature clearly made a determination that it was not going to include that limitation on back pay, which this court has previously interpreted as an intention to allow for recovery during the entire period of discriminatory conduct, given that the purpose, there's no way to make this right without allowing for recovery during the entire period of discriminatory conduct.
We have statutes of limitations for most causes of action. I understand the argument that you shouldn't be able to, you shouldn't be barred from recovering within recent years how you've been harmed because of some misconduct that occurred long ago. But it does seem to me novel, and I hear you're agreeing with me that it's novel, this notion that you could go back, say, 20, 30 years worth of wages. That's not the way our legal system normally operates, is it?
Your position that there should be somehow what would essentially be an arbitrary limitation on the amount of back pay would be reading a limitation into the Iowa Civil Rights Act that isn't there, and it would have broader implications because, in fact, we currently allow for hostile work environment claims recovery during the entire period of discrimination, regardless of whether it was 10, 20, or 30 years. And
I'm not taking a position. I'm just asking and exploring, and that.
Sure, and the Iowa Civil Rights Commission has repeatedly asserted that the damages that are awardable under the Civil Rights Act are during the entire period of discriminatory conduct, and that's particularly well supported for policy reasons when you're talking about a wage discrimination claim, because not only were our plaintiffs sent home for 15 years with a smaller paycheck than their male counterparts, but Allsteel also pocketed all of that money. So as Ginsburg points out, the employer benefits directly from its discriminatory conduct in a wage discrimination claim where the employee has no means of being made whole. And I would suggest that I think the legislature, when faced with choosing between the employer who has acted discriminatorily, because of course that would be required to be proved in order to succeed under the statute, and the employee who has been discriminated against, the legislature opted to favor the victimized employee by allowing them to recover damages during the entire period of discrimination. So, and also I think, so in conclusion, we are asserting that the first certified question should be answered, that the amount of damages recoverable under the clear language of the statute are during the entire period of discriminatory conduct. And then if the court reaches the second question, that the amount of damages recoverable under 216.6 would also be during the entire period of discriminatory conduct.
Thank you, counsel. Rebuttal, Mr. Harty?
Thank you, Your Honor. Briefly, I'll simply address 3 points. First, with regard to the Hy-Vee decision and the interpretation of the Hy-Vee decision with regard to this case, it is it's pretty clear when reading Justice Wiggins's opinion in the Claypool case and Chief Justice Cady's opinion in Farmland that Hy-Vee is limited to its facts, that it involved a breached settlement agreement, that it involved implicit bias, that it involved segregating, systemic segregation. It didn't involve the issues that we have here in the facts as provided by the federal court, and therefore it's clearly distinguishable. There was a statement that the Civil Rights Act contained a 2-year statute of limitation, and I don't think it was intentional, but that's just wrong. The Title VII did not contain any statute of limitation of 2 years until after the Fair Pay Act was passed in response to the Ledbetter decision. Before that, it was a 180-day or 300-day recovery period as based on the claim filing requirement contained in the statute, which is the same statute of limitation that is contained in the Iowa Civil Rights Act, as the Claypool decision very clearly states. That's not just a claim filing time, it is the statute of limitation. And then two final issues with regard to statutory interpretation. Again, both the amicus and plaintiffs have alleged, asserted, argued that since its inception, the Iowa Civil Rights Act prohibited wage discrimination based upon sex. And that's just not true. When it was passed in 1965, the Iowa Civil Rights Act prohibited discrimination on the basis of race, religion, and national origin. And it was intended, and the writings of Professor Bonfield make this clear, that it was intended to address the conditions of the time, which involved refusals to hire African Americans and segregating African Americans into low-level jobs. It wasn't until 5 years later, that sex discrimination was added to the Iowa Civil Rights Act.
How is that germane, though, to the overarching argument, which, as I understand it, was that at the time of the recent amendments, there had been at least decades of a claim of wage discrimination based on sex?
This court, two responses, Your Honor. This court has addressed, really only in the Farmland Foods case, the pay issue. And I cannot we'll get into the weeds if we talk about federal law. This court has adopted a sort of a cafeteria approach to looking to federal law, which I think is admirable, because federal law is, as is the case in this case and as we briefed extensively, extremely different in a number of respects. But why it's important, the history is important for this reason. This law has now been on the books for almost a half century. Next year, it'll be a half century. It has been amended no less than 27 times. And on each of those occasions, never has an amendment been deemed by the legislature to be retroactive, nor on each of those 27 occasions has this court ever ruled or interpreted that the amendment was retroactive. This case does not present the scenario that would cause, and the legislature didn't deviate from that practice, and there's nothing in the case that would justify this court from doing so. With that, Your Honors, unless the court has additional questions, we'd stand on our brief.
Thank you, counsel. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.